let's go live to CP24's crime analyst, Steve Ryan, with more on this. And Steve, regardless of your political stripes, conservative leader is echoing what a lot of Canadians are feeling right now.
It certainly has sparked conversation, Jamie, when it comes to bill reform and the release of violent offenders who are on a multiple bail. So I'm joined now by Joseph Neuberger. He is a criminal defense lawyer. Joseph, thanks for your time, and we're going to talk everything bail.
Yeah, okay, ready.
Bill C75 requires the release of an accused under the earliest opportunity under the least onerous conditions. What does that mean, and is that affecting bail hearings?
I don't think so. So first of all, Bill C75 had a number of principles emphasized, which includes what's behind a bail hearing in order to ensure that an accused attends court, does not repeat offenses, and then their release doesn't bring the administration of justice into disrepute. What it wanted to address was, even at that time, it acknowledged that about 60% of people in custody were awaiting trial. So that's a very high number. So they wanted to streamline the release process, giving some more powers to officers to move certain matters out of the bail court where they will have power to release, and to deal with the more serious cases in the bail court. I don't think Bill C75 in any way sort of addresses the issues that are being raised now by the community, although I think the bail system is rather robust, but there are certainly some issues with how the criteria for release are being applied. In particular, what we call the tertiary ground, which is how strong the Crown's case is. And in strong cases with multiple releases, I just don't understand, bail, because I've seen cases with far less going on and people are detained.
So when we look at repeat offenders who are out on multiple charges for violent offenses, what is your opinion as to how that is explained? I mean, it is a concern for communities.
Yeah, no, I understand that. And I think, again, everybody has to appreciate that of the total amount of cases that are being heard by the Ontario Court of Justice for bail, and those are primarily before justices of the peace, the bail system is working rather well to manage risk. And we have some cases, which of course hit the media right away and social media, which concerns the public. It's nothing necessarily new. We've had these offenses going back over decades, but it's more prominent now because of the immediacy that we have with media. That said, there are certain aberrations that have to be addressed, where you have somebody out on a release for a very serious offense with a criminal record, and there's another offense with a firearm. Something has to be done in order to hammer home to the courts the seriousness and why these people should be detained, because they provide a very serious risk to the community. I'm thinking that there may be some tweaking to provisions with respect to certain category of offenses as to how you deal with that on bail. And that may be an alternative, and that may be something that the Liberal government is thinking about now.
So just to clarify, Bill C75, that's not an order to justices of the peace and to judges to release people? Am I right on that?
Well, no, it's legislation. So Bill C75 amended the criminal code, and it put in additional provisions for police officers to have powers for release, and it emphasized the principles that are at play. So it amended the criminal code to some extent, but these are things. The criminal code is something that justice of the peace must follow. But there's also case law that comes into effect as well. So they have to take into consideration a constellation of facts. But the principles remain the same. If a justice of the peace is faced with somebody who has a criminal record, a very serious offense, and it's a strong case for the prosecution, that does not augur well for somebody to get released. So when we do have these cases where somebody's out on multiple releases, gun-related offenses, those to me are concerning because the provisions are there and the case law is there to detain.
How much of a role does overcapacity in our provincial detention centers play, and the length of time it takes a person from charge to trial? How much of a role does that play in people being released when perhaps they shouldn't be?
Okay, so let me break that down into two questions. One, we now have an increase in people in custody who are awaiting trial. So I think, our numbers are more closer to about 70% in the provincial institutions on remand. That means they're sitting there waiting to have their trial, many of which will be found not guilty. So that is a pressure on the system. But that's not a pressure necessarily that a justice of the peace should take into consideration if it's a very serious case before them. It certainly is a factor overall. The other issue is, how long does it take to get to trial? Not that bad these days. The courts have done a very good job in moving matters along and bringing down delays. And if you're in custody, a trial can be heard within several months of the arrest and detention. So I think the system has done a very good job in dealing with backlogs. There still are cases that are backlogged due to certain circumstances. They may be very complex cases, but cases are moving along at a very good pace.
I appreciate your time as always. Good to see you. Thanks, Joseph.
You too. Thanks, Steve. Be well.
Back to the desk.
Thanks for that, Steve.